topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Welcome to Ask the Experts, where we provide you with awesome experts. And I know it might seem like Steve's voice sounds funny, but no, this is Rebel. And we have an expert for you today where he is going to tell us all about some interesting things. Bankruptcy law. Oh, wow. It's just something else, I tell you. Well, I'm going to let Kevin come on and tell us a little bit about himself while I get everything situated. Hi, Kevin.
Oh, how you doing?
I'm good. How are you?
Okay, good. Thanks for having me on the show today. Look forward to talking to you guys. I guess we'll talk about a little bit about bankruptcy today.
Yeah, I think that's where we're going to start off and see where everything goes. So,
sure.
Bankruptcy. It's a scary word for some people. Is it as scary as it used to be?
No, it actually was never scary, but people hear things on, cocktail parties or whatever they're doing, all these horror stories, or they watch the movies or TV where people are penniless or in the street and that kind of stuff. That's not how bankruptcy works. Bankruptcy is simply debt relief. Most people don't understand there's different chapters of bankruptcy. So when someone says they're filing bankruptcy, most people will think like Chapter 7, which is basically a straight bankruptcy, a liquidation of assets. But in reality, you don't really liquidate anything because if you're going to lose something, you're not going to probably file that. So it's federal law, but state exemptions when you file bankruptcy. And every state has different exemptions. But basically, like you can have a job, a house, a car, and it's just a matter of how much equity you're allowed. It's a fresh start, so you can move on. Then they have restructuring programs like Chapter 13, Chapter 11, Chapter 12. Chapter 9 is for government, 12 is for farmers, 11 is a corporation or a more complicated person. Chapter 13 is like a personal bill consolidation, a personal restructuring of debt, where you keep all your property, keep all your assets, and you make payments to creditors with no interest to unsecured creditors usually, with up to 60 months. And even if you could pay faster, you don't have to, and you get to keep everything. So it's really nice. It's also used more to stop foreclosure, save your house, catch up on the arrears, get your driver's license back, stop a car from getting repossessed, or if you had it repossessed, to get it back in Chapter 13. It's another use for Chapter 13. Chapter 7 is just basically you keep your car and reaffirm. You have secured debt where you could keep your items and pay for it. Like, for example, a car, you keep it and pay for it, or give it back and owe nothing. So there's all kinds of ways to either get out of debt or restructure debt. It's not always Chapter 7, which you could do every 8 years. It's called a fresh start. And there's no stigma. I mean, everyone has their own stigma, I guess. But like you'll be getting loan offers right away. You can get cars, you can get mortgages. Are you going to get them a month later, 2 months later? Maybe not. Okay, but it's not 10 years or 8 years or anything like that. You can restructure your credit. Oftentimes, if you file bankruptcy, your credit score may go up as soon as you file because part of it is your debt to income ratio. So the first step to getting out of debt, or the first step to fixing your credit is to get out of debt. That's the first step. And then just move on.
Well, good afternoon, Kevin. This is
Hey,
Steve
Steve.
O. Hey, you know what? We do a live show, and a lot of people don't like doing a live show just for this reason. You never know when you're going to have a technical problem, which we are having today. But Kevin, I got a letter the other day from a listener, and they wanted to know if they filed bankruptcy, and 2 months later a bill showed up that they forgot to list. Can they come back and list that?
Yeah, so here's how it works. So you file the case. That's what they call your petition date, right? And you got to list all your assets and liabilities. But now let's say, it's a medical bill or an old collection you forgot about, or maybe it was a debt you listed, but now they have a collection agency on it that you just got notified on. So you got to file an amendment, that's all. So basically you amend the petition to include them because the case goes from the time you file the case until you're discharged, it's roughly 4 to 4.5 months, okay? Now, sometimes, let's say a different question, suppose it's not 2 months. Suppose it's after the case is discharged. Then what do you do, right? So depending on the debt, if it's unsecured, this happened just yesterday, or the day before to one of my clients. He says, hey, this payday loan's calling me. It's on the schedules. Well, it wasn't because he didn't disclose it, but it's discharged anyway because once I put them on notice, had they been discharged anyway, they still would be. Now, if there's fraud involved or something like that, they can reopen the case. But basically, the simple answer is, yeah, you just amend your schedules to add it. So if it's 2 months later, amend it, add it on there. Actually, you're supposed to amend it. You want to have all your documents as detailed as possible when you file bankruptcy. But there are ways to get out of debt even when it's not disclosed, as long as you didn't intentionally not disclose it and there's no fraud involved and the unsecured debt. Just talk to your lawyer. It's not a big deal. I mean, it's a big deal, but it can be taken care of.
See, I think some of these people hear you and they like you better than their lawyer they had.
Well, but I've been doing it a long time. So.
I got to tell you that I had another person who asked me, I thought it was a great question. How do you know when to file for bankruptcy? At what point of your debt? Because the guy's letter basically said everybody tells him not to file bankruptcy, that he doesn't owe enough. But he said, I am up against a wall. What do you do in that case, Kevin?
Well, the first thing I do is stop talking to people. That happen. I mean, I get that all the time. They say, oh, my neighbor, my friend, and my teacher's daughter's cousin filed a case 10 years ago. They don't know anything. Everyone's case is different. Okay. There's no minimum requirement to file bankruptcy. Okay. Now, if you came to me and it's a real small amount, I would ask you, because you can only do it for every 8 years. But like if you owe 10 grand, are you filing bankruptcy? Maybe, maybe not. 10 grand to one person is $100,000. It's all relative. How much you make, how many kids you're trying to feed, someone garnishing your wages. So it's all relative. So there's no minimum requirement. There's no answer. It's what's best for you. So just talk to a lawyer. Most people like myself, they give free consultations and, we can help you through it. And it also depends on what kind of debt it is. People say, okay, I owe 10 grand, 5 grand, 20 grand. Okay, but how much is like priority or non-priority? Is it tax debt? Can it be dischargeable or not? Is it secured debt? Is there, fraud involved or student loan, stuff like that. So there's a lot of different questions. The question someone was asking is it's a very general question, and the friend still doesn't know. So there's a lot more to it than that. But basically, just call somebody because, quite frankly, everyone's situation, you got to deal with, you got to deal with yourself.
I got to tell you, it's bankruptcy. Hiring somebody like you, I am telling people that it's a way to get a elephant off your shoulders. And, I think it's so important that if they sit down and meet with you, Kevin, and go over all their options, and you show people a lot of different options.
Correct.
It's amazing. First of all, once they sign with you, Kevin, they don't have to talk to creditors anymore, do they?
No. So that's a good point too. So your first comment, the consultation is free. Most bankruptcy lawyers will give you a free consultation. That could be in person, it could be by phone, it could be by Zoom. It's nice when you have your debt list. I mean, I don't mind the free consultation to people, but let me know what's going on. Don't be just like, be a little bit prepared. I mean, how much do you owe? Who do you owe money to? Are you being sued? Is there a court date? Is it being garnished? I mean, give me some facts. But it's basically when you file is depending upon, like, let's say you're in foreclosure and you got to sell your house, in 2 days. You got to file now. It's got to be Chapter 13. You know what I'm saying? So, there's sometimes it's like, sometimes there is an answer. It's today or it's tomorrow. But like on a Chapter 7, I mean, I have clients, that they got the court date of being garnished. Maybe the garnishment already started. Well, you could actually get back up to 90 days worth of garnishments, depending on the amount and how much you could exempt. You could actually get some of that money back, or sometimes all of it. So, but the sooner rather than later. And if someone's got a court date, they just don't want to go to the court. Just might as well file. Now, as far as getting the creditors off your back, before we file the case, you give them our phone number. Most creditors will call to verify representation. In other words, everyone says, "Oh, I'm gonna file bankruptcy." Just tell the creditor, and they're gonna, they're not stupid. I mean, they're gonna call me and they're gonna look at the webpage. Is he really a bankruptcy lawyer, or is he your cousin who does estates and wills? So they call, they see it, they say, "Okay, are you retained by Mr. Smith, or Miss?" "Yes, I am." "When do you think you're going to file?" You give them an estimate. They'll make a note, and they'll just, they'll circle back if they don't get a notice. But in reality, the collection companies, the collection agencies, they're on commission, right? I mean, they're not just going to be stupid and say, "Okay, you said so, I'm going away." But if you're really filing and they talk to me and I verify it, well, they got other debts to start trying to collect on. You know what I'm saying? And they can make some money. But they will, if it's not filed, they say, "Hey, what's, a month ago you're filing, what's the status?" And sometimes what clients do is they go away. We're taking the phone calls. No one's bothering them anymore. Everyone forgot about it. They quote unquote charged it off. They think, they don't need me anymore or need their lawyer anymore and everything. Well, guess what? You go AWOL on me, the creditor calls, "Are you taking care of Mr. Smith still?" "Not anymore." You got his phone number, call him directly, and they'll start calling you. So, if you think it's going, silent, because we're taking your calls. But I don't want to take your phone calls. I'm not a secretary. Let's just get your case filed. Now, once I get the case filed, they get a notice from the court, notice of filing. Now it's a court order. It's called the automatic stay. They can't call you. Now, I filed the case right now. They call you in an hour. They didn't know yet. They call you tomorrow. They just give me a case number. And they just go on a thing called Pacer, the government site, and they just verify it. They wouldn't even bother me. They just give them the case number and they'll go away. Otherwise, they're violating a court order, a federal court order, and you can sue them for automatic stay violation. And if they call you after the case, it's a discharge violation, and you're entitled to some money. So they will not, some people do, but most creditors will. They don't want to they don't want to violate the order. So yeah, we'll take your phone calls until we're filing the case. But quite frankly, I can get your case. If you give me all the documents and stuff, I can file a case in a day or two. You know what I'm saying? So for most cases, I mean, I had a case
Kevin,
a week ago.
When a person decides to sign with you, they can do that through Zoom. Is that right?
Well, I mean, I could do the consultation with them. It could be by Zoom or phone or in person. Okay, most people don't even want to come in. They do it by phone. But I could do Zoom or in person. Um, our file system is online in the cloud, so wherever you are, I mean, even if you live close, some people don't want to come. Sometimes I make you come in. So it's only if you're screwing around and you can't get me document, just come on in and just give me your stuff. Let's just go. Otherwise, I'll just drop you. I'm saying because it's not rocket science, right? I need some documents for you, some information. I mean, give it to me. The fee we're quoting you is not to be chasing you around for documents and stuff I give you, or I tell clients I need X amount of pay stubs and they give me part of it. I mean, come on, was this kindergarten? I mean, give me help me help you. I'm saying so. That's not hard, and no one's tricking you. And if it's a problem with your case, I'd be the one telling you before we file the case, right? So it's just a matter of getting things done. But yeah, most people, we have an online file system. So basically, you sign up with me. We send you an email with a link, and then you create your own portal. It'll say you've been invited to Benjamin Legal Services client portal. You choose your own login and password. From that point, you and I could do secure communication, document upload, calendar events. If I send you a secure message, it goes to your email box, but it says from Kevin Benjamin. There's a little green box in it. Hit the button. If you send me a message secure, it comes to me. Plus, my secure client messages go to a certain box. So when I get busy during the day working or whatever, I could just check real quick the client messages, right? Oftentimes, I give clients a direct line as well, as long as they don't abuse it, which they could actually text me or call. So basically, most clients don't abuse it. So the texting is not for legal advice or legal analysis. It's like, hey, did you get my email, or can we do a call, or maybe I'm texting you, hey, where's your pay stub, whatever. Oh, Kevin, yeah, it's on the way. It's for short administrative stuff. I'm saying the secure messages are actually privileged. That's more detailed. Or if there's something that's a problem, we can even schedule. You could come to the office, but we could schedule a Zoom or schedule a call. Now, before we file your case, we have to go over all the documents with you: the petition, the schedules, what they call statement of financial affairs. If you're doing a Chapter 13, a plan, means test, all these papers. But basically, when you're on the online file, I'll tell you what I need. Then we have an online questionnaire. So from your comfort of your home, you could start working on the questionnaire, save it as you go along. Tell me about you, your assets, your liabilities, your budget, and then when you sign it, when you're done, I get notified so I can look at the information. I start drafting the documents that have to be filed. So you have my online file, upload the documents through the questionnaire. Now I can draft everything. Now, once I'm drafting it, I may text you a question. I may send you a message. Hey, what's this about, or what's happening with it, or did you get a new bill on this? I'm not going to play phone tag with you. Just it's a simple question. When you get the message, you respond. Now we have the draft. At that point, we do what's called a petition review, because you got to sign it, and you're signing on a penalty of perjury. I'm drafting it for you with the information you're given, right? And let's make sure we're not missing anything. So then we either meet in person or Zoom or phone, whatever you want to do. And if you come in person, I just print it out. If you're doing a Zoom review, I'll put the PDF versions of all the documents in your file so you can have it in front of you. And I'll go over page by page. Here's what it is. And oftentimes, when I'm going over it, I could see some discrepancies and start asking some questions just to help you. Maybe you forgot something, or, go from there. But otherwise, you're telling me, oh no, I'm missing a creditor. Well, let's put them on there. Make sure we have the debt list all current. Or no, this Kevin, the amount of money I had in my bank account, that was from last week or last month when we were doing it. Now it's this. Let's change the number. Let's change the exemption. There's bankruptcy planning. There's exemption planning. Timing of a case, right? Do you qualify for bankruptcy? Chapter 7, you have an income and a means test. Sometimes the income fluctuates, and sometimes there's deductions you can take off of income to qualify somebody. So sometimes I may say, something, we're not filing now because you don't qualify, but you qualify in 2 weeks, you qualify in a month. I have a couple clients, right? I mean, one guy just was 3 months ago. He didn't qualify because he did one eight years ago. He qualifies in 3 months, so we're doing documents and taking the creditor phone calls. Why do it 13? It's 3 months, which is only about 6 weeks to go, and we just filed the case. But now he's cooperating, so we just keep revising the stuff. So when he qualifies, boom, there you go. Otherwise, sometimes it's an income situation. You got a big a bonus before, maybe you're making less. So the government formula says you're making money, but you're not. But that changes every month on the formula. I don't want to get too detailed in front of you. That's why you have a lawyer. But that's timing, bankruptcy planning, exemption planning. Make sure you don't lose anything that you don't want to lose, and or do a different kind of case and talk about maybe you have a lawsuit against somebody. Can you file bankruptcy still? You sure you can. You got to disclose the lawsuit. Let's say it's an injury case. Okay. Maybe you have a lawyer ready. Okay. You got to disclose you have an injury case. You have an exemption. Depending on the state, it's different exemption. You just simply disclose it. If you're doing a Chapter 13, maybe you're going to put that into the plan, the non-exempt money, as a bonus if you want to. Otherwise, you can structure it where you're making payments in another matter. Maybe you have a workers' compensation case, 100% exempt. Still got to disclose it. Or you're suing somebody because they defamed me or they owe me money. Okay, you disclose it. Is it really collectible? Maybe not. Because once you file a bankruptcy case, any claim you have is now a claim of the property of the estate of the Chapter 7 trustee, right? So, if you I'm going to sue this guy go ahead and sue him. The trustee may just abandon it and say, have that. Saying they don't mind, if it's not really something they can actually collect upon and administer is the word, because they administer assets, right? So they're paying for it. They got to collect, they got to pay the cost, and they have to do a distribution to a meaningful distribution to the unsecured creditors after costs and fees. So they analyze things. I mean, I have a case going on right now. Actually, there was emailing me as we were on the show. A lot of properties involved, right? We just converted it from a Chapter 11 to Chapter 7. A lot of 10 properties, right? But there's no equity. So there's a contract on it right now. The creditor is modifying the stay. We're going to work it out basically in the 7. And my client was worried about is the 7 trustee going to take it? There's no equity. So there's nothing to administer. But you got to disclose it. They got to see for themselves what's going on, and then you just you just move on.
Well, I hate to get political. Maybe this isn't political, but we just had a text come in. How come Trump doesn't declare bankruptcy?
Well, first of all, people claim that he has, and he really hasn't. He has filed in the past Chapter 11s on the businesses, which are corporate restructurings. So that's not a personal case. Debts incurred by fraud are not dischargeable. So if he tried to file bankruptcy, he's just going to be litigating the case inside the federal court. They're going to be claiming misrepresentation. There's a lot of different ways to try to challenge somebody's debt. But if you do it inside bankruptcy, the creditors would love it, okay? Because in bankruptcy, when you want to get discharged from that, and if somebody wants to accuse you, it's called through an adversary proceeding. It's very liberal discovery, a lot more than state court. They can ask you a lot more questions, and you got to show documents. And I don't think Trump likes to show stuff. So it's not a matter of, hey, the judge said I owe $300 million. Okay, but the judge said you owe whatever the number was. They said it was for fraud. So, the BK is not going to help him in that case.
I guess really the question is, if somebody has a civil charge and the penalties are really high, can you write those off?
Depends what it is. So like for example, there's different kind of cases. So yeah, sometimes you could write off the interest and penalties. Sometimes if it's more of a criminal nature, or depending on what it is, sometimes part of it is, sometimes it's more complicated. I can probably go on the show right here. Someone should really call me. But the short answer is yes. Sometimes, oftentimes you can. Now, for example, parking tickets, for example, right? They're not dischargeable in Chapter 7. Now, first of all, so those are fines, right? But they're not dischargeable in Chapter 7. Now, sometimes the entity, the town, whatever, they just write it off anyway. But you can file a Chapter 13 and pay them a couple pennies on the dollar, and it's discharged. It's called a super discharge. So there's different discharges, and that's why you have a lawyer. It's like, hey, can I get rid of this? Well, what kind of case are we doing? In a 7, no. In a 13, yes. So the child support orders, right? They're not dischargeable, but debts pursuant to a marital settlement agreement that are simply property settlements are dischargeable. So people get confused, like, well, I can't discharge it because it's a court order. I got to pay X. No. If it's not related to a domestic support obligation, then it is dischargeable. Now, sometimes what you do is you bring me the middle settlement agreement where the judge said, and I'll look at it. I'll tell you, because sometimes it's like X dollars, the client's talking about, but you got to break it down from the X. The court order may say this is for the child support, this is alimony, this is basically just like 20 grand for paying bills. That part's dischargeable. So we'll work with that as well. So taxes and fines can be handled in different kinds of cases. Sure.
Well, we this is going to bring us to the close of our bankruptcy show. We're going to do our tax relief show now. And Kevin, you are so good at when it comes to tax relief. And by the way, if you somehow found the show and you're in a different state, when it comes to federal tax, Kevin can help you. And all you got to do is give him a call at 312-853-3100. So whether it's bankruptcy or tax relief, and Kevin, I've got so many questions for you when it comes to tax relief. Did you become a bankruptcy attorney first or tax relief first?
Bankruptcy. I got into tax resolution through bankruptcy. Oftentimes people would file bankruptcy and you have tax debt. So, let's say you file Chapter 7. So, the IRS gets notified, and they usually contact us and say, hey, there's $40,000 owed, and the automatic stay is in place, and, we're going to honor the automatic stay. And when the case is over, they're going to, resume collection or try to work it out. Now, sometimes taxes can be dischargeable, which some people don't know. But let's say it's not, right? So, but, oftentimes someone was filing a case not because of the IRS debt. It was for a different reason. So they got out of the rest of the debt. And now if the taxes are dischargeable, great. And by the way, we can analyze the taxes before you file the case to see if they're dischargeable or when. That's part of your bankruptcy planning, right? Timing. So what happened was sometimes people would have non-dischargeable taxes. Okay, start doing offering compromises or installment agreements or settling debt with the IRS post bankruptcy. Now, oftentimes because the debt was cleaned up, they didn't have $500 or $800 a month on credit card payments, and it's a little easier budget to work out with the IRS, the different programs. And what most people don't understand is the IRS wants to resolve your taxes. There is a criminal division, but most taxes, it's not criminal. There's exceptions to that, of course. But mostly it's just a matter of money, right? So it's your ability to pay. The IRS will settle your debt for your ability to pay. Now, that's just the general way, right? So what is your ability to pay? What's the bare minimum offer, right? Well, you submit an offer on the basis of what you could pay, and then you got to say there's different kinds of offering compromises, for example. Doubt as to collectability, doubt as to liability, effective tax administration, which is like a, currently non-collectible, penalty abatement. So they will settle for what they deem feasible to pay, but that's why you have a lawyer. Okay, what's my ability to pay? What can I, basically count and not count? It's an exercise in cash flows, assets, liabilities, income. Some assets can be liquidated faster. Some maybe an asset really can't. You're saying even assets that can be liquidated, you're not liquidating it, not from compromise. You're just trying to figure out, if I was, is it really something I can liquidate? And then plus, what kind of discount can I get from the IRS? Because, you do fast sale, that kind of stuff. That's all negotiable. There's IRS standards of expenses. There's also how much do you owe? Is it a streamlined program, a non-streamlined program? You got to submit documents with your offer or not? Is your case with what they call ACS, automatic collection systems, or is it with maybe a revenue officer, which is now maybe on a program where you weren't need documents, they want them anyway. You know what I'm saying? So that's why you have a lawyer. So basically, though, we figure out what's your ability to pay based upon, the IRS, the Internal Revenue Manual, and the offer and compromises and the means to, or the IRS standards of expenses. So I can analyze what I think it is, right? And now we have X. Now we have X number. Okay, let's say it's $10,000. Okay, so that's where you get this crap on these national companies and we settle on pennies on the dollar BS. There's no magic where you just call the IRS and say, "Hey, I'm a shrewd negotiator. I'm going to give you some pennies." It's a formula. What's your ability to pay? And show me, right? So if that's what your ability to pay is, that's what it is. So if it's 10 grand, to use easy math, and if you owe 10 grand, it's 100 cents on the dollar. But I can maybe get you 72, 84 months, right? Or if it's 100 grand, and it's an offer and compromise, it's 10 cents on the dollar. If you owe $1 million, it's a penny in the dollar. But if you owe $1 million, it's a penny. It's still 10 grand. If you owe $100,000, it's 10 cents on the dollar. It's still 10 grand. If you were paying, 100%, it's still 10. It's 10 grand. So there's no, magic there. Where people say, and most people don't always qualify for the offer. Okay, but that's okay, because even in an installment agreement, you can get length in your favor, and they have a partial pay installment agreement. So you're actually making a partial payment. Now the IRS, when you make an offer, that's why you have a lawyer or someone, a professional who does this, because you want to analyze what are your options. How is the IRS looking at this? Because if you're offering an offer and compromise, let's say I say, you qualify for an offer, but here's how it would look to me. And it's yes, I'm negotiating with the IRS. But also, how is the IRS going to look at it from an installment agreement? They may say, well, wait a second, I could take 10,000, but I can get 40,000 in an installment agreement because they have the ability to pay over a year. So then you may be wasting your time on an installment agreement. However, sometimes let's say it's 10,000 and maybe it's 15 on an installment agreement, right? They still may take the installment agreement because it's one in the hand or two in the bush, whatever the phrase is. For the little extra, 5, 7, 8 years, things could go wrong on an installment agreement. Maybe you're not really getting paid. They gotta watch the file. There's costs involved. So it depends on the difference of whether we make an argument to say, hey, something, you're getting more in an installment agreement, but here's IRS why the offer, even though it's a little bit less, here's why it's a better deal for you. Okay, and that's what part of the negotiations are. And by the way, there's different levels in the IRS. Okay, so you submit an offer if it's turned down, and the IRS has the discretion to turn them down or not, right? But you can appeal it, right? I mean, so it's not just over. You know what I'm saying? There's an appeal process. There's a tax court. I belong to the tax court. I'm an attorney. Not all attorneys do belong to the tax court, but I do. But I'm not saying you're going to the tax court because usually you just resolve the matter. But sometimes when you go to the appeals, you get the more experienced revenue officers or agents than on the front lines who understand what you're saying on the expenses. And they honestly, on the appeals, it's not like like in court where it's work it out. You're saying, okay, Kevin, maybe I see maybe you're right. Maybe that expense should be counted, and the offer is more what you said, and we were saying no. Now we'll take it. okay? Or they're saying, here's why, and you're negotiating, and there's different levels of the appeal, and how far you want to go with it, and that kind of stuff. So, but while you're doing that, we represent you with the IRS. They're not calling you, they're calling me, right? So we want to make sure, the first thing we want to make sure we do is protect you, right? You hire us, let's get a power of attorney on file with the IRS. We're on the job. Let's call them up and get a collection hold. Are they trying to leave you? Can we stop that? We'll get into the case. We get a copy of the IRS file. Where are they on the file? Are you complying on your tax returns? How much do you owe? Are they about to levy you or garnish you or attach assets? How far in the process are you? So let's figure out what's going on, right? So that's my job, right? So, you don't want them knocking on your door, and you don't want them to take things. And they don't want to take, they just want to make the offer. But if you're not calling them to you, if no one's talking to them, they don't know what you could pay or not. They just know no one's, they find the assets and they're just trying to take it. So, and there's a way, if they got assets already, sometimes you can get them back. It's more complicated. So don't wait till then. You can call me now if you need help. Since January 1, they're coming hard. A lot of the pandemic breaks, they were, backing off a little bit on some of the collection stuff. That's over as of January 1st, 2024. They're doing full-born collection. They got $80 billion from the government over several years. They're adding collection people, and they're coming. They're really coming after, especially now, people that what they call high income, 100,000 or more. There's also the millionaire people with the write-offs and the airplanes. I mean, there's a whole lot of things that they're coming. It's not always income tax.
Are they going after
payroll
middle
tax.
class too, Kevin?
It depends on what you think of the middle class. Well, they're coming after everybody. You know what I'm saying? So, high income is high income 100,000 or more. Is that middle class? You know what I'm saying? But they are aware that there's people with money that don't pay, or they have a little more creative accounting or something like that, and they're getting prepared for that because there's more money to be collected on there. But yeah, but they're coming after everybody. But the thing is, though, even if you're like middle class, lower, they're work. I mean, if your debt is like less than $50,000, it's easier, right? I mean, now $50,000 is a lot of money, right? But I mean, we got people, 4 or 5, 800,000, more. You know what I'm saying? And it's not always income tax. So, there's a lot more debt out there than people realize. But, what do you care? How much do you owe, and are they bothering you? But 50 grand's a lot, but that's actually, if we get down to 49,000, I could probably get less, I'll probably get a deal with you with no documents. You get down to 10 grand, you could it's a lot of things you can do. You know what I'm saying? So there's also the expiration dates, right? What they call the CSED, the collection statute expiration date. So you owe $40,000, he's telling me, but in reality, it's over maybe a couple of years, 2, 3, 4, 6. I mean, I got all kinds of people, right? So to you, it's 40 grand. To me, it's 12,000, 6,000. And then what's the expiration date on each one? And are you complying? Like I had someone come in just the other day, they're going to owe, because now it's tax season, right? They're going to file, they're going to owe more money. Well, first of all, you got to be compliant, so you got to have to file. It's not due yet, but you might as well file now, because if you owe another 20 or 30, let's just put it on, on the deal right now. Because if I'm doing offer and compromise, let's sell that one too. Because remember, if we back up my example with the $10,000, right? You owe 40,000, now you owe 70. It's still 10 grand. The settlement. So it's because your ability to pay hasn't increased because you owe more once you file your taxes tomorrow. You know what I'm saying? So now if it's an installment agreement, there could be partial pay, all those kind of things. So there's a lot of things to consider. That's why you don't want to do it yourself. I mean, you got to talk about your eligibility requirements, the application process. Are you filing financial documents or not? Are you self-employed, or just you got more things to show, more documents? Or are you just a wage earner? Maybe it's a little easier. Are you tax compliant? Are you going to stay compliant? What happened to get behind? You know what I'm saying? Oftentimes people, they just think I'm behind. I can never catch up. I owe so much money. I owe $1 million. What am I going to do? I'm going to kill myself. But it's like, don't do that, of course, because if you're like, say middle class, you owe $1 million, which some people, maybe they had a company before, whatever. How am I going to pay $1 million, Kevin? You're not, because you don't have the ability to pay that. So first of all, you may have a currently non-collectible situation where they will actually show them, and for 6 months to 2 years, just back off, because you have a hardship, right? But let's say you don't have that, right? It's still, what's your ability to pay? Yeah, I had a business, but went under $1 million. Now I'm making whatever here. I'm a taxes. This, I got 3 kids. It's your ability to pay, and they'll settle it, through us with you. So don't think it's a big number that I'm screwed. What can I do? Call them, because it's a big number. If you don't call them or have someone represent you on this stuff, I'm not saying call yourself. You should have us do it, but they'll come after you. They'll garnish you. They'll leave you. Take your assets. You don't want that, right? Especially when it could be so much easier resolved than you think. I'm not saying everything's easy, right? But it's easier than you think if you have a professional, because that's what we do. And the IRS is willing to play ball. You just got to know the rules and how to play the game, so to speak. You know what I'm saying?
Once they get that letter, that's the first, how they're contacted versus a letter, Kevin?
Yeah, there's like a CP type of form. I mean, there are all kinds of different letters. So usually I tell the client, just give me letters, okay? Because there's different letters, different codes. So it'll tell me if you're in, where you are in collections. Are they about to leave you? Some letters say final notice of intent to leave you, but it's actually not the final notice. So, but maybe it is. You know what I'm saying? So, let's take a look at it, because again, if you have that, you're not screwed. You hire us, let's get in there, like, get the power of attorney of the IRS, like today, if we can. I mean, right now it's past 5 almost, but I still get it in. But then like tomorrow, you want to get the collection hold, or if you hire me in a day, let's get it in. Let's get the collection hold on there. Let's get into the case. And they're happy. The IRS is happy to help. I mean, they want to, Kevin, show me what it is. And they know I just got hired and I got to get my financial questionnaire in there, that I know what the IRS is looking for. I know what documents they're looking for, if, depending on the amount of debt, if documents are required. And they're happy to have us do the work and start showing them why it should be taken an offer.
You've got so many different ways to help somebody. I mean, it's not a cookie cutter. I was surprised when we did our first show, and you know what? Just as a host of a show like this, I felt better after talking to you. So you can imagine with someone who owes back taxes. Now, I got to ask this for our last question, because I get this like, what is Fresh Start?
The Fresh Start is just the marketing gimmick. You're entitled to settle. It's a Fresh Start program. That's really what it is. I mean, years ago, the IRS came out with the Fresh Start initiative, and let's get you compliant again, make deals. But now a lot of these marketing companies, they start, hey, a new program. It's the Fresh Start program, and you're allowed to just call us, and everyone qualifies for a deal. Whether it's 100% or 10% or 2 cents on the dollar, or partial pay or full pay, or a settlement, or not collectible, or penalty abatement. There's ways to resolve things. So it's not a new program like these people try to make you sound like. And when I say these people, I mean these national companies that are just telemarketing companies, and they got a call center, and it's a Fresh Start initiative. And guess what? You call them, everyone qualifies for an offer of compromise. So just give them some money. They got you, right? Until you pay them, and then you try getting someone on the phone who's working in your case. You want to have someone like me, or someone a little smaller. I handle your case. I'm the one you're dealing with. You know what I'm saying? So that's how it works. But we're not a marketing company. We don't play that game. I just tell clients the facts, and most professionals do. I'm saying is, a lot of these national companies are being sued right now. I don't want to name some names. You can Google it. It's like the loan modification scam, the debt collection scam. it takes years, and then there's a house of cards, and then it falls. Okay, there was in the past, there was some other companies that we settle pennies in the dollar. It took years before they went down. Right? There's another lawyer. You can Google it. They were doing millions. Right? How many cases can you do? Right? So you're taking money in, but now who's watching the fight? You know what I'm saying? So now you got to get this. So it just falls apart, right? So because now I got to make more money to pay the marketing, to pay the $1 million for the TV ads, and all that kind of stuff. And now that's a different model, right? You want someone like, I'm not the only person in the game, but someone who's really going to do it. You know, so I'm not doing that. I mean, I'm licensed in different states. I'm licensed in the tax court. I'm licensed in different federal jurisdictions, different state as well. Not every state, but federally I am. So I'm in the U.S. tax court. I could do a lot of stuff, but we don't market like hey, I'm a national guy. You know what I'm saying? Why? You know what I'm saying? I mean, I'm just trying to help people. It's easier for me if you're more local because it's more trustworthy. I have clients that hire me after they've been burned by the national companies. I had just two of the last couple of weeks. I want to come see you. Okay, I'm here. You know what I'm saying? It's still appointment only, by the way. Don't just walk into my office and I'm on the show right now. I'm working on I'm making an appointment with you. But happy to see me because you want to know who you're dealing with, right? So don't worry about this. Even on a Zoom, it's like these national companies. So what? I mean, it's a call guy. They have such a high turnover where they churn and burn the call center or the people or the attrition rate. It's unbelievable. And I've seen the contracts in some of these national companies. It's unconscionable, some of these clauses they have on there. I've seen them trying to waive. You can't sue us for fraud. You can't sue us for small claims. You can't sue for class action. What are you worried about? Of course, first of all, of course you can.
Kevin,
you can't waive that stuff.
Just give everybody your phone number and your website, how they can reach you.
Okay, benjaminlaw.com, 312-853-3100, 312-853-3100. It's Benjamin Legal Services at benjaminlaw.com. We also run a completely tax resolution company called Noble Tax Relief, which is nobletaxrelief.com. That website it's just IRS tax stuff. It's still me. I mean, either way, you're doing it. The law firm does tax resolution. Obviously, it's me. We do bankruptcy. We do foreclosure stuff. So the website for the law firm, which is being revised, it's going to be launched a new one in a couple of days. Only has a limited amount of stuff on there. But the tax relief at nobletaxrelief.com has a lot of Q&A and a lot of information. But either way, it's me who you're going to be talking to. I'm the person who's going to be on the power of attorney. I'm the authorized person with the IRS. I'm the IRS point of contact. I'll be your point of contact. So either way.
Well, we got to go, Kevin, Attorney Kevin Benjamin. We are so lucky to have your firm. Hey, you'll be back again with us next month on the Ask the Expert Show. Thank you, Kevin Benjamin, Attorney Kevin Benjamin, 312-853-3100. And we will be back with you again next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert Show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.